Swayam Prabha. Digital India. Educated India.
Okay, well students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 15th lecture and the topic of today's presentation is rights of inmates of prison. So, I have chosen this topic so that I can explain you the rights available to inmates of prison in our legal system. So, in this lecture I would like to highlight constitutional provisions, constitutional safeguards provided to prisoners, constitutional provisions which are helpful to protect rights of inmates of prison, and then after I will try to explain statutory provisions under which prisoners, inmates of prison, they can get relief. So, I have chosen this topic so that you can get entire information about rights of prisoners, because this rights of prisoners has got a new recognition in criminal justice system. So, for your convenience I have classified their rights into three categories. So, we will try to understand rights of inmates of prison in our constitutional scheme, and what are the rights of prisoners in under Prison Act 1894, and what third important thing is that how far Supreme Court has been effective in recognizing rights of prisoners, rights of inmates of prisoners. So, with the help of these three important provisions, with the help of these three methods, we will try to understand the rights of inmates of prison. So, as I just told you that firstly we will try to understand the rights of prisoners provided in our constitution. Constitution being supreme law of the land guarantees certain rights to the citizen of this country, as well as constitution itself has provided certain remedies, certain rights to the inmates of the prison or to the accused against whom allegation is made. And second important thing is that we will try to understand the efficacy of his statute, particularly the Prison Act 1894. So, we will try to understand that how Prison Act 1894 has been effective in recognizing or protecting the rights of inmates of the prison. And third important thing is that we will try to understand the role of Supreme Court in recognition of rights of inmates of prison, how Supreme Court has played important role in recognizing the rights of prisoners. So, with the help of these three things we will try to understand. Now, let us understand our constitutional scheme. As you all might be knowing that Article 21 of the Indian Constitution talks about right to life and personal liberty. So, I would like to explain this Article 21 firstly, because you all might be knowing that right to life is a very precious right, and all the democratic countries, they have recognized right to life as basic rights, and this right to life has been recognized as a human right in UDHR. Universal Declaration of Human Rights 1948 talks about right to life as a human right. So, according to, I just want to refer that provision of UDHR, Article 3. Article 3 of UDHR specifically talks about right to life. Every human being has right to live with human dignity, irrespective of caste, creed and religion. Every human being has right to live with all human dignity. So, this is Article 3 of UDHR 1948, and in our constitutional scheme, Article 21 talks about right to life as a fundamental right. No person shall be deprived of his life or personal liberty except procedure established by law. So, this Article 21 gives liberty to the citizen of this country, to any person, citizen as well as non-resident of India, they can enjoy. So, that is why person word has been used under Article 21, that all human beings are equal and they can enjoy their right to life. So, Article 21 gives liberty to a person in India to live with all human dignity. And this right to life can be enjoyed by every person in India without making any discrimination. State will not make any discrimination on the ground of. So, Article 21, which is directly connected with right to life, if person is arrested, if person is kept behind the bar, if person is kept in prison, then question may arise that where a person who has been arrested or has been kept in prison, so merely because of allegation or merely because of putting him in prison, he may be deprived from his right to life or he may be deprived from his precious rights. So, as you all might be knowing that all means every person has right to live with human dignity, and even accused are also entitled to avail all the rights, fundamental rights, except few. They do not have liberty to express their view in the prison, though to some extent this right is, but their freedom of movement is curtailed once they are arrested by the arresting officer. So, they cannot enjoy their freedom of movement. So, there are certain rights, freedoms which they cannot enjoy, but except few fundamental freedoms, fundamental rights, even prisoners are also entitled to avail all the fundamental rights, because they are human being, and being human being they are also entitled. Before I start constitutional provision, I would like to refer few important provision of UDHR and India too. Why I am referring UDHR, that international instrument? Because India too is party of that international instrument. India is also signatory member of international instrument like International Covenant on Civil and Political Right, UDHR. So, because of that reason, we are also bound to incorporate all the things which are mentioned in UDHR or ICCPR 1966 in our legal system, and we have incorporated. So, that is why I am trying to correlate UDHR, ICCPR with our constitution. So, you see how Article 5 of UDHR specifically talks about protection against inhuman treatment, right against cruel punishment. Article 5 of UDHR talks about right against illegal arrest, unwanted arrest, inhuman treatment, and Article 10 of this UDHR talks about right to fair trial, and Article 11 of UDHR provides that every person shall be presumed to be innocent unless his guilt is proved before the court of law. So, you see this UDHR was the Universal Declaration of Human Rights came into existence on 10th December 1948, and since then all the democratic countries have been trying to incorporate all these human rights in their legal system, as well as all the democratic countries on this universe, they have been trying to protect all the human rights provided in UDHR, and India too has paid due respect towards human rights provided in UDHR. So, we will try to understand the entire concept of rights of inmates of prison with reference to UDHR, with reference to ICCPR 1966, So, that is why I have just referred these two important international instruments, ICCPR and UDHR. So, Article 5 of UDHR talks about protection against inhuman treatment, protection against illegal arrest, protection against unwanted arrest, cruel punishment. So, we will have to understand the rights of prisoner in our legal system, in Indian legal system, in the light of these international instruments. So, let us understand rights of inmates of prison under constitutional provision, under Indian constitutional provision. So, article I have just referred article 21, prisoners are also entitled to live in prison with all human dignity. Right to safety, that is paramount concern of right to life. The prisoners are also entitled to live safely in prison. So, you see article 20 of Indian Constitution talks about three types of fundamental rights, three types of protection. Article 20 has three clauses. Article 21 talks about protection against ex post facto laws. Article 20 clause 2 talks about protection against double jeopardy, and Article 20 clause 3 talks about protection against self incrimination. So, I will discuss all these three fundamental rights one by one. So, with the help of this slide you can understand, with the help of this constitutional safeguard. In this slide I have highlighted constitutional provision, so that you can get entire information regarding constitutional safeguards. So, you see I have referred this article 21, which talks about right to life. Article 22, right to have counsel. Right to be, article 22 has two important clauses. Article 22 you see talks about right to be produced within 24 hours before magistrate. And article 20 clause 1, protection against ex post facto laws, ex post facto laws, and article 20 clause 2, double jeopardy. Many of you might be aware about this, so that is why I have referred only article double jeopardy. And article 20 clause 3, that is protection against self incrimination. So, let us understand these precious rights in the light of international instrument UDHR and ICCPR. So, you see article 22 talks about right to have a counsel. So, you see every arrested person has right to get legal assistance from his counsel. So, legal representation is also a guarantee to the accused or as well as to the prisoners who are in prison. So, prisoners as well as arrested persons suspect, they have right to engage their counsel, they are entitled to get legal assistance from their counsel. So, without legal representation, no criminal court can decide their case. It would be injustice on the part of the government if criminal court decide any case without providing counsel to an accused. Whether accused is poor or rich, it is immaterial. It is legal duty of criminal court to ensure that whether accused who has been brought before the court or who has been brought before the court has been provided legal assistance, or whether he is poor, if he is poor, accused is poor, then whether he has been provided legal assistance free of cost. So, you see these two important things, right to legal aid and right to free legal aid. Every arrested person and every prisoner has right to get legal aid from his legal counsel, and every prisoner has right to get legal aid free of cost if that prisoner is not in position to engage his counsel in court of law. So, it is the duty of court to provide counsel free of cost to that accused who is not in position to engage his counsel, his advocate, due to poverty. So, this constitutional mandate, this constitutional provision provides an effective safeguard to an arrested person or to a prisoner, so that arrested person can be produced within 24 hours from the time of arrest to the magistrate. So, if accused is produced within 24 hours from the time of arrest, then there would be very little chances, or there would be no chance, no possibility of torture or physical violence against the accused or against the arrested person. So, our constitution maker, they had idea about police atrocities, they had idea about custodial violence. So, in order to avoid, in order to prevent custodial violence, custodial torture, our constitution makers, they provided these safeguards in our constitutional scheme, and Article 22, 20, 21 and 22. These three important provisions of Indian Constitution, Article 20, 21 and 22, these three important things, provisions are directly connected with rights of inmates of prison, rights of arrested person. As I said, Article 20 clause 1 talks about protection against ex post facto law. So, no person, no accused shall be punished for that act which was not an offence on the date of commission of the act. So, this kind of protection is given under Article 20 clause 1 of the Indian Constitution, so that an innocent person whose act was not an offence on the date of commission of the act could not be prosecuted and convicted for that act which was not an offence on the date of commission of. So, this protection against ex post facto law, this is a guarantee, this is a fundamental right available to an accused or suspect. So, no accused shall be convicted or prosecuted for that act which was not an offence on the date of commission of the act. So, this is guarantee provided in Article 20 clause 1 of the Indian Constitution. Now, let us understand Article 20 clause 2, protection against double jeopardy. How this protection against double jeopardy plays important role in providing relief to the accused, to the prisoners. You see, where a prisoner who has been convicted, prosecuted and convicted for an offence, and the same person is again facing same charges, if criminal court is going to prosecute the same person for the same offence, then it would be injustice. So, that accused can, that person who has been already convicted and acquitted by the criminal court, convicted or acquitted, if the same court is, criminal court is going to prosecute and convict him for the same offence, he can take the defence of Article 20 clause 2, that is double jeopardy. No person shall be vexed twice for the same offence. So, this kind of guarantee is available in Article 20 clause 2. Once the charges against the accused is initiated by the criminal court for the same offence, he can take plea before the court that he has already been convicted by the same court for the same offence. So, that is why it would be violation of his fundamental right guaranteed under Article 20 clause 2. It is double jeopardy. So, this would be violation of Article 20 clause 2. The moment accused pleads this defence before the court, then court will not try the case and he can get the benefit. So, you see this how prisoners can take the benefit who has already been convicted or acquitted in any offence. They cannot be prosecuted and convicted for the same offence. Double jeopardy. Third important thing is that protection against self-incrimination. So, under trial prisoners who are waiting for their trial, they cannot be compelled by the authority to confess their guilt, neither in the prison nor in the police lockup. No accused who has been arrested by the police, neither investigating officer nor prison authorities can compel to the accused or to the prisoner to confess their guilt. It would be violation of their fundamental right provided in Article 20 Clause 3 of the Indian Constitution. Article 20 Clause 3, as you all might be knowing, that talks about protection against self-incrimination. No one can be compelled to be a witness against himself. The moment if someone is compelled by an authority to confess his guilt, it would be violation of his fundamental right guaranteed under Article 20 Clause 3 of the Indian Constitution. At that very moment, his fundamental right would be violated by the authority, by the prison authorities. If superintendent jail has compelled a prisoner to confess his guilt with the condition that if that prisoner would confess his guilt, he would be acquitted, or if this kind of inducement is given by superintendent jail, or if any inducement is given by investigating officer to the accused, that his punishment would be mitigated, his punishment would be reduced, or if that arrested person or if that prisoner who is in prison, under trial prisoner, if he confesses guilt, his punishment would be reduced or he may be acquitted, then it would be a kind of inducement, and it would be also considered by the court that prisoner was compelled by the prison authority to confess his guilt. So, it would be violation of fundamental right, and that prisoner can take defense of Article 20 Clause 3 of the Indian Constitution. So, you all need to remember these three important aspects of criminal justice system, where accused, where prisoners, they are entitled to get benefit of Article 20 Clause 1, 20 Clause 2 and 20 Clause 3. So, protection against self-incrimination, this is also a guarantee. Section 24, 25 gives more recognition to this fundamental right, because Section 24 of the Indian Evidence Act and 25 of the Indian Evidence Act, Section 26 of the Indian Evidence Act, these three important provisions of Indian Evidence Act are directly interconnected. 24 talks about no inducement shall be given to an accused for what? For obtaining confession. No threat or inducement shall be given by police to the accused, or confession made by an accused in police custody. Confession made by an accused to the police would be irrelevant. That statement cannot be proved as a piece of evidence against that confessional statement, as you all might be knowing, that cannot be treated as piece of evidence. So, in order to protect rights of prisoners, these statutory provisions as well as constitutional provisions have been provided in our legal framework, in our legal system. So, you need to remember all these things. Now, come to statutory safeguards. In this slide, we will try to understand. Now, you look at this screen. Now, statutory rights of prisoners. The prefix which I have added, statutory rights of prisoners. So, it makes it clear that we are talking about rights of prisoner under specific statute, under special statute, statutory rights of prisoners. So, you all might be knowing that right now we are having this legislation, the Prison Act 1894, The Prison Act 1894 talks about rights and remedies, powers and duties performed by the prison authorities, and rights and remedies available to the inmates of the prison. In nutshell, I would like to highlight some important rights which are available in this statute. The first important thing is that prisoners are entitled to have food, right to food. They are entitled, prison authorities, prisoner, whether he is convict or under trial prisoner, they have right to get food from the authority. Where prison authority has failed to provide food to the prisoners, it would be considered as the prison authority has breached its legal duty, and it would be treated as that authority has violated statutory rights of inmates of prison. So, jail authorities are bound to ensure this statutory right, first thing. Second important thing is that right to medical aid, right to safety. Prisoners are entitled to live safely in prison. Many times you must have seen that prisoners are also killed in prison, or prisoners are also assaulted in prison. So, either by inmates of the prisoner or by jail authorities. So, they have right to live peacefully and right to safety, that is paramount concern of right to life. So, this right to safety, this thing you need to remember. Right to medical aid, where any prisoner, whether he is convict or under trial prisoner, is entitled to get medical assistance from the prison authorities. It is legal duty and legal obligation of jail authority to provide medical assistance to those prisoners who are sick or who are suffering from any mental disease or physical disease. So, they can get, prisoners, they can get medical facility as per this statute. So, you all need to understand that this statute, Prison Act 1894, also talks about right to medical aid and right to safety. Right against solitary confinement, third important right is right against solitary confinement. So, you see, no accused shall be kept in prison in isolated cell, or you see, this right against solitary confinement means solitary confinement is a place or is a very small cell in a prison where prisoners are kept in isolation. They are not allowed to talk with other inmates of the prison, they are not allowed to meet any. So, even this kind, many study reveals that where prisoners are kept in isolated cell, either they become mentally ill or they have to face so many problems. So, they can be kept in solitary confinement, but there is statutory provision in their entire punishment. They can be kept in solitary confinement for not more than 3 months. That 3 months must be counted as per the rules prescribed in the statute. This 3 months should not be continuous, there should be a break between these 90 days, 3 months, and these are statutory provisions where you can see that prisoners under this statute, they can enjoy their rights, not enjoy, but it would be not appropriate word, but rights have been recognized by this statute, and prisoners are also entitled to avail those rights available in this statute. It is legal obligation as well as statutory right of prisoners that female prisoners shall not be kept along with male prisoners. It is the duty of jail authority to ensure that female offender should not be kept along with male offender. This Prison Act 1894 also talks about that thing. Now, come to third important area which I have chosen, that is role of Supreme Court. So, in this slide we will try to understand the role of Supreme Court. Right to free legal aid is fundamental right, in which case Supreme Court for the first time held that right to free legal aid is a fundamental right. I have referred to important cases: M.H. Hoscott versus State of Maharashtra, AIR 1978 Supreme Court; Khatri versus State of Bihar, AIR 1980 Supreme Court. So, this is the first case. M.H. Hoscott case is the first case where Supreme Court declared a right to free legal aid as a fundamental right, and Khatri versus State of Bihar, that is second important case. So, I would like to give brief summary of Khatri versus State of Bihar case. This case is also known as, popularly known as, Bhagalpur blinded prisoner case. As you all might be knowing that in Khatri versus State of Bihar, what happened? 31 prisoners, they had lost their eyesight, and facts of this case is that 3 police officers were involved in that incident. Additional session court acquitted them. When CBI went in appeal in Patna High Court, then out of 3, 2 police officers they were convicted. For what? For blinding them, for pouring acid in the eyes of 31 prisoners. So, due to lack of proper evidence, 1 police officer was acquitted and 2 police officers were convicted in this case by Patna High Court. And you might be knowing that the things which happen in police lockup, there is no direct eyewitness. In police lockup or in police station, only police officers are there. So, if if victim of crime is asked by the court that victim of crime should provide, accused should provide direct witness, eyewitness in this case. So, it would be very difficult for accused who has been put in police lockup or in prison to provide eyewitness in that case, because police are eyewitness in the case, and no third party is not allowed, third person is not allowed. And it was the year of 1980, 1979. So, you can imagine that how a person could have approached, the advocate could have contacted to higher authority. So, in this case, in Khatri versus State of Bihar case, when 31 prisoners, they were assaulted, they lost their eyesight, they became blind, and since they were not in position to represent their case, so it was decided by an advocate to fight the case of victim of crime, and in this way this matter was brought into the notice of Supreme Court, and ultimately Supreme Court held that all the victim of crime, 31 prisoners who were blind due to wrongful act of police officer, were entitled to get compensation from the government concerned, because they were acting on behalf of the government. So, they were entitled to get compensation from the government. On the other hand, Supreme Court also made one important observation in this case. Supreme Court held that all the prisoners were poor, were not in position to represent their case. So, they were entitled to have counsel right from the arrest till the completion of the trial. Two important observations which Supreme Court has made in this case, that right to free legal aid is a fundamental right, that is essential component of right to life and personal liberty. Right to life would be meaningless for those poor people who do not have sufficient means to engage their counsel in the court of law. So, right to life would be meaningless for those poor accused, poor prisoners who were unable to engage their counsel in the court of law. So, they are entitled to have counsel right from the investigation till the completion of trial. This is the first observation which Supreme Court has made in Khatri versus State of Bihar case. Second important observation which Supreme Court has made in this case, that is right to compensation as a fundamental right. All the victim of crime, all the prisoners who had lost their eyes were entitled to get compensation from the government concerned. And in this way, Supreme Court recognized that right to free legal aid and right to compensation is essential component of right to life or personal liberty. So, this is second important case. Now, come to this third important case, right to speedy trial. You just look at your screen, right to speedy trial. You all might be aware about a proverb that justice delayed is justice denied. So, where justice is delayed, that is denial of justice. So, the leading case on this point is Hussain Ara Khatun versus State of Bihar, AIR 1979 Supreme Court. What happened in this case? Hussain Ara Khatun case, many of you might be aware about the fact of the case, but this is very important case on Article 21. You see what happened in this case. I just want to explain this case. In 1977, you just look on your screen, 1977, there was a NPC, National Police Commission. National Police Commission was constituted by Government of India just to give valuable suggestions so that police reform can be done in this country, and police reform was needed. So, Government of India decided to constitute a commission, National Police Commission 1977. That commission was also assigned a task to visit entire jail of the whole country at that time and take a feedback from the accused, under trial prisoners. So, one member of that National Police Commission, was K.V. Rustam. So, he wrote an article, and that article was published in Indian Express newspaper. Since Rustam was a member of National Police Commission, he had visited so many jails, and when he visited different jails of Bihar, so he found that many prisoners who had been languishing in jail of Bihar, either they had committed very petty offences, and in spite of that, since they were not in position to represent their case due to poverty, so he wrote an article, and his article was published in Indian Express newspaper. In that article, it was specifically mentioned that many prisoners in Bihar were languishing in jail for more than the period required for their offence to which they were charged. They were languishing in prison for more than that period. If they would have been punished, they would have been acquitted. So, this matter was taken into notice, and that the article published in Indian Express newspaper along with application was filed in Supreme Court by Kapila Hingorani, Puspa Kapila Hingorani. She is considered as mother of public interest litigation in India. As you all might be knowing that Justice P.N. Bhagwati, he is considered as father of PIL in India. Similarly, Kapila Hingorani is considered as mother of PIL, mother of public interest litigation. So, she mustered her courage to fight the cases of those victims who were not in position to engage their advocate counsel in the court of law on account of poverty. So, she filed a petition in Supreme Court along with cutting of newspaper, wherein one member of National Police Commission had expressed his thought. So, Supreme Court accepted her letter as a later petition, and in that letter she had highlighted that Hussain Ara Khatun along with 17 other female prisoners, they were languishing in jail for longer period. So, that matter was brought into the notice by Kapila Hingorani, and her letter was considered as later petition. And finally, Supreme Court held that right to speedy trial is essential component of right to life or personal liberty. Where justice is delayed by authority, by court, it would be denial of justice, and justice delayed is justice denied. Right to speedy trial, that is fundamental right, essential component of right to life or personal liberty. So, in this case Supreme Court held that those female offenders who were languishing in jail for longer period should be acquitted, because they have already undergone more longer, means they have already served more punishment, imprisonment, which they had been convicted for that offence. So, they must be acquitted. You will be surprised to know that as a result of that 40,000 prisoners across the country were acquitted only because of judicial intervention, only because of Hussain Ara Khatun case. About 40,000 prisoners were acquitted during that period. So, Supreme Court took cognizance that something is going wrong in this country, and Supreme Court said that right to speedy trial and right to free legal aid. Hussain Ara Khatun, she was not in position to engage her counsel due to poverty. She was poor, she was not in position to afford advocate fee and court fee. So, that is why she was, and she was also ignorant about her law. She was not in position to pay court fee or advocate fee. So, right to free legal aid, Supreme Court also recognized right to free legal aid is essential component of right to life, and it is constitutional obligation of state to provide free legal aid to those poor people who are languishing in jail due to poverty, due on account of poverty. So, this is another important case where Supreme Court has played important role, vital role in recognizing human rights of prisoners. Now, let us understand this rights of prisoner in the light of this judicial pronouncement. Right against inhuman treatment. The leading case on this point is Sunil Batra versus Delhi administration. Many of you might be aware about this case. I have also referred Article 5 of UDHR. Article 5 UDHR 1948 talks about right against inhuman treatment. It is specifically mentioned in Article 5 UDHR that right against cruel punishment, right against inhuman treatment, right against unwanted arrest, illegal arrest, that is human right. And if that right is violated by authority, it would be violation of human right, and authority concerned may be compelled to ensure this right, as well as authority may be compelled to provide compensation to the victim of crime. So, what happened in Ruddal Shah case, I have highlighted this case, Ruddal Shah versus state of versus Delhi administration. Article 5 UDHR and Sunil Batra case. Then we will try to understand Ruddal Shah case. In Sunil Batra versus Delhi administration, what happened? Sunil Batra was a convict, and he wrote a letter to a judge of Supreme Court by highlighting the plight of inmates of Tihar Tihar jail. So, in that letter, Sunil Batra had highlighted the plight of an inmate of prison who was very close to Sunil Batra, and the name of that prisoner was Premchand. So, Sunil Batra wrote a letter to a judge of Supreme Court by stating that warden of jail, Tihar jail, and jail superintendent of Tihar jail, they were demanding bribe from the visitors of Premchand, and warden or superintendent jail, they had warned Premchand that if you will not pay money to the staff of Tihar jail, that prisoner Premchand would be tortured, would be. So, this kind of allegation was made by Sunil Batra, and all the allegations were specifically stated in that letter. That letter was accepted by that judge of Supreme Court, and that letter was considered as letter petition under Article 32. Supreme Court accepted that letter. And when all the allegations was inquired by the Supreme Court, all the allegations were true. Supreme Court found that all the allegations stated in that letter was true, and on the basis of that allegation, Supreme Court held that India is a signatory member of international instrument in International Covenant on Civil and Political Right 1966. India is also signatory member of UDHR 1948. So, now time has come to follow, to comply that international, to express international commitment, and Article 5 of UDHR was referred in this case. Supreme Court said that Article 5 specifically talks about right against inhuman treatment. So, in this case, in Sunil Batra case, Supreme Court for the first time held that right against inhuman treatment, that is fundamental right under Article 21 of the Indian Constitution. Wherever ill treatment, inhuman treatment is done by the authority against the prisoner, it would be violation of right to life guaranteed under Article 21 of the Indian Constitution. So, in Sunil Batra case, Supreme Court held that prison authority had failed to comply Article 5 of UDHR, and where inhuman treatment was, where an inmate of Tihar prison injustice was caused to an inmate of Tihar prison, it was violation of right to life or personal liberty guaranteed under Article 21 of the Indian Constitution. So, Supreme Court for the first time held that right against inhuman treatment, protection against inhuman treatment, that is a fundamental right, that is essential component of right to life. Even prisoners are also entitled to live with human dignity. Merely because of detention, merely because of arrest, a person cannot be deprived from his precious rights guaranteed under Indian Constitution. So, Supreme Court has, you see, Supreme Court has, in this way Supreme Court has evolved compensatory jurisprudence. The right to get compensation is a fundamental right, right against inhuman treatment, right against illegal arrest. So, Supreme Court through judicial pronouncement has recognized certain human rights as essential component of Article 21 of the Indian Constitution, which was not directly enshrined under Article 21 of the Indian Constitution. So, with the help of this case, Sunil Batra case, I think you all have understood the things regarding protection against inhuman treatment. Now, this another important aspect of human rights of prisoner, that is protection against handcuffing. You see, handcuffing is necessary to keep an offender within legal framework, handcuffing is necessary, but under what circumstances under trial prisoner or convict can be put in this situation. Supreme Court for the first time held that in Prem Shankar Shukla versus Delhi administration held that handcuffing is against Article 5 of UDHR. Article 5 clearly talks about protection against inhuman treatment. So, Supreme Court said that where handcuffing is necessary to put a prisoner behind the bar, he might abscond, there is possibility that prisoner might abscond or he has made attempt on several occasions to abscond from the prison, then in that situation handcuffing is justified. Otherwise, handcuffing is violation of right to life guaranteed under Article 21 of the Indian Constitution, because prisoners are also entitled to live with human dignity. Handcuffing is against Article 5, handcuffing is against Article 21, mandate of Article 21, that handcuffing is permitted, but this thing can only be done under exceptional circumstances, and exceptional circumstances is where there is a threat from the prisoner, that prisoner is habitual offender, he is very hardcore criminal, or he has made an effort to abscond from the prison. Under these circumstances handcuffing is allowed. Otherwise, handcuffing would be treated as violation of right to life or personal liberty. Protection against torture, as you see, this protection against torture is also a human right. This kind of protection is available in Universal Declaration of Human Rights 1948. Article 5 is very important, Article 10 is very important, right to fair trial. Article 11 of UDHR, which talks about presumption of innocence, every person is presumed to be innocent unless his guilt is proved before the court of law. So, because of that presumption, all the prisoners are entitled to avail all the freedoms except few, only because of human being. So, Justice V.R. Kishnaiyer has already expressed his view that no accused, no prisoner can be deprived from his precious right merely because he is a prisoner, merely because he has committed any offence. So, he must be provided all the benefits, all the fundamental rights which he can have except few freedoms. So, there are two important case laws which I would like to refer. First is Kishore Singh versus State of Rajasthan, and another important case on protection against torture, that is Moti Ram versus State of MP, AIR 1978 Supreme Court, in which Supreme Court has held that bail is a rule and jail is an exception. Bail is a rule and jail is an exception. Right to bail, that is another important. Right to bail, you see, right to bail is important right in the hands of prisoners, particularly under trial prisoners are entitled to be released on bail. This important right to bail, is not available to hardcore criminals, to habitual offenders. Habitual offenders or hardcore criminals, they are not entitled to be released on bail, but Supreme Court has already evolved, or Supreme Court has issued various guidelines wherein accused can be released on bail. So, in Moti Ram versus State of MP, AIR 1978 Supreme Court for the first time held that bail should be a rule and jail should be an exception. In exceptional criminal case, accused must be kept in prison Otherwise, jail should be a rule. More and more offenders should be released on bail. When I am referring this statement, don't take it otherwise. More and more offenders should be released on bail, particularly those prisoners who have committed offence which are not punishable with more than 7 years imprisonment. So, where prisoners who have committed offence which is punishable with not more than 7 years imprisonment, considering the gravity of their offence, they must be released on bail. So, by doing so, we can reduce the pendency from criminal courts. On the other hand, we can also expedite, we can also provide speedy justice to the under trial prisoners, because speedy justice is also essential component of right to life. Right to bail, right to appeal, this is also precious rights of inmates of prison, where and because of why right to bail or right to appeal, these two rights are important rights to the inmates of the prison. Because of that concept, every person is presumed to be innocent unless his guilt is proved before the court of law. That is a human right provided in Article 11 of UDHR. So, because of that presumption, under trial prisoners are entitled to get bail from the court. So, if we incorporate this thing and if we follow this principle evolved by Supreme Court in Motiram case, we can reduce the pendency of criminal cases, as well as our Indian legal system can provide speedy justice to the prisoners. By doing this, incorporating this right to bail, criminal court must ensure that the amount of bail bond should not be so high, so that prisoner who is poor, he cannot provide that surety, the amount of surety due to poverty. So, the purpose of bail is to release the accused. So, criminal court while fixing the amount of bond should always consider the financial position of the accused, so that he may be released, and the purpose of bail should not be defeated. So, you see, these are the things which I have just discussed in this lecture, rights of prisoners provided in our Indian legal system. So, I have highlighted constitutional provisions. I also highlighted statutory provisions and role of Supreme Court in recognizing rights of inmates of prison. So, with the help of these three things, you all can understand the rights of inmates of prison: constitutional safeguards, statutory safeguards, and role of Supreme Court in recognition of human rights of inmates of prison. So, I have highlighted case laws so that you can get entire information about judicial contribution, judicial effort, particularly role of Supreme Court, and Supreme Court has recognized right to legal aid, right to free legal aid, right to bail, right to compensation as essential component of right to life guaranteed under Article 21 of the Indian Constitution. With this, I would like to conclude this lecture, and I do believe that you all have understood these things, the things which I have just discussed in this lecture. So, with this I conclude this lecture. Thank you all.